Hello, my name is Mike Khalilpour, and I'm a senior associate at the Green Law Group here in Simi Valley, California, and head of the firm's estate planning practice. Today's webinar is all about estate planning, which I believe is one of the most important steps anyone can take to make sure that their final property healthcare wishes are honored and that their loved ones are provided for in their absence. This webinar is general information and educational in nature, and for your specific matters, please be sure to talk to an experienced estate planning attorney. You don't want to take anything I say today as the absolute gospel or the only way to do things, since the law does tend to change on a regular basis, and so what is true today may not be true tomorrow. There may also be exceptions to the general rules that would apply to your particular situation. This is designed to be background information to help facilitate the conversation, and probably multiple conversations that you want to start having now. Now, you may be thinking that estate planning is only something that high net worth individuals need, but nowadays all individuals need to plan for when something happens to them. You don't have to be super rich to do well in the stock market or real estate, both of which produce assets that you will want to pass on to your heirs. Even if you're only leaving behind your primary residence, if you don't decide who receives the property when you pass, you won't have any control over what happens to it. The main component of estate planning is designating heirs for your assets, and without an estate plan, the courts will often decide who gets your assets, a process that can not only take years, but rack up fees and have the potential to be a public and ugly fight. The secondary component of estate planning is making sure your small children are taken care of based on your wishes. No one thinks of dying young, but if you're the parents of small children, you need to prepare for the unthinkable. This is where the will portion of an estate plan comes in. A third component is being able to plan for and minimize any estate taxes, sometimes referred to as death taxes, that may be owed to the federal government. Estate planning is all about protecting your loved ones, which means in part giving them protection from the IRS. Essential to estate planning is transferring assets to heirs with an eye toward creating the smallest possible tax burden for them. Even just a little bit of estate planning can enable couples to reduce much or even all of their federal or state estate tax liability. There are also ways to decrease the income tax beneficiaries might have to pay. Without a plan, the amount that your heirs will owe Uncle Sam could be quite a lot. Finally, having an estate plan eliminates family messes. We've all heard the horror stories. Someone with money dies and the war between the family begins. One sibling may think they deserve more than another, or one sibling may think that they should be in charge of the finances, even though they're notorious for racking up debt. Such squabbling can get ugly and end up in court, family members pitted against one another. Stopping fights before they start is yet another reason why estate planning is necessary. This will enable you to choose who controls your finances and assets if you become mentally incapacitated or after you die, and will go a long way towards quelling any family strife and ensuring that your assets are handled in the way that you intended. It will also help you make individualized plans if necessary, to arrange for a child with health problems or to set up a trust for one who might be better off not inheriting a lump sum. It can also help give you more to a child who did most of the work of caring for you in your later years, or less to the one whose extensive education you funded while paying far less for their siblings. Deciding whether to divide your estate exactly equally is one of the key tasks you need to think through. And of course, if you've had more than one spouse or have children from more than one family, an estate plan is urgent. Now, what is an estate? In a nutshell, an estate is everything comprising your net worth, including all land and real estate, possessions, financial securities such as retirement accounts, investment accounts, or bank accounts, cash, business interests, or really anything else that you own or have a controlling interest in. In thinking about what you may need for your estate plan, there are a number of documents that a typical plan includes. First, a will, which is a document that provides instructions on how your property and custody of minor children, if any, should be handled after your death. It is written to express your wishes and names an executor that you trust to fulfill the stated intentions. The will also indicates whether a trust should be created after death, or if a trust has been created, disposition of any properties or assets that are not already transferred into your trust. To ensure that your children are cared for in a manner of which you approve, You'll also want to think about and name their guardians in the event that both parents die before the kids turn 18. Without a will that names these guardians, the courts will step in to decide who will raise your children. While this is arguably one of the most important documents in your estate plan, a will by no means avoids probate. You might be thinking, what is probate? Probate is a legal process that takes place after someone dies. It makes sure property and possessions are given to the correct people, and any taxes or debts that are owed are paid in full. If there's a written will, the court checks that it was signed and witnessed properly and is otherwise valid, and then makes sure the directions in the will are carried out. There's typically 3 main reasons why you want to avoid probate. First of which is time. It can often take several months or years to probate an estate after someone's death. Second reason, money. It is often very expensive to probate an estate, the statutory fees that are paid to the court, executor, and attorney. And third, privacy. Probate is a court process, and with most court proceedings and documents filed with court, they are open to the public. Now you might be thinking, how do I avoid probate? Generally, 3 ways to avoid probate. First is creating a living, or sometimes referred to as a revocable trust, which holds all of your assets. Second is to make sure you name beneficiaries on things like your life insurance, retirement accounts, investment, and/or bank accounts. Third, with respect to real property, make sure they're jointly owned. Now, with living or revocable trusts, at the most basic level, this is a trust. It's a written document that determines how your assets will be handled after you die. As I mentioned earlier, assets can include real estate, valuable possessions, bank accounts, and investments. As with all living trusts, you create it during your lifetime, and assets you place in the trust are then transferred to your designated beneficiaries upon your death. What sets a revocable living trust apart is that you can change or cancel provisions at any time during your lifetime, hence the name. The living trust allows you to have flexibility and control in how and when assets are going to be distributed, and can help protect these assets from the debts of a beneficiary. Also, since living trusts are private documents, assets placed in the trust and distributed do not go through a public probate process. Living trusts are also provide flexibility for estate planning and savings, especially for married couples. Coupled with a pour-over will, these 2 documents can serve and should serve as your primary estate planning documents. Additional documents that could be or should be a part of your estate plan is an advanced healthcare directive. An advanced healthcare directive is a document that explains how you want medical decisions about you to be made in the event that you cannot make the decision yourself. An advanced directive lets your healthcare team and loved ones know what kind of healthcare you want, or who you want to make those decisions for you when you can't. An advanced directive can help you think ahead of time about what kind of care you want, might help guide your loved ones and healthcare team in making clear decisions about your healthcare when you can't do it yourself. An advanced directive is meant to help you plan ahead and let others know what kind of care you want. It is used as a guide for your loved one's healthcare system in making clear decisions about those medical decisions by yourself. These medical decisions may include special actions or emergency care from your healthcare team, or it can specify do not resuscitate decisions that you have made and can address organ donation wishes. Advanced directives only apply to healthcare decisions and do not affect financial or money matters. For financial and money matters, another document to consider is the durable power of attorney. Durable power of attorney is a legal document that gives someone you choose the power to act in your place. In case you ever become mentally incapacitated, you'll need what are known as durable powers of attorney for finances and other business affairs. Durable power of attorney simply means that a document stays in effect if you become incapacitated and unable to handle matters on your own. With valid power of attorney, the trusted person you name will be legally permitted to take care of important matters for you. For example, paying your bills, managing your investments, all if you're unable to do so yourself. Conclusion, taking the time to make these documents is well worth the small effort it will take.
We're here to help if you have any questions or need help in drafting any of the documents mentioned in this webinar. Please do not hesitate to contact our office. Thank you.